for coming out on this cold and blistery day to hear more about this lawsuit filed by 13 public school parents and 1 educator to challenge the illegal appointment of Kathy Black as the next New York City Public Schools Chancellor. This lawsuit reflects the diversity of New York City. We have parents from all 5 boroughs who have joined together to challenge this illegal appointment. This backroom deal, the circumvention of New York State education law by Commissioner Steiner to satisfy our bully mayor, Michael Bloomberg, is unacceptable to us, is unacceptable to the 1.1 million public school students, and it's unacceptable to the 1.1 public school families. Our kids, after 8 years of failed education reforms, deserve a quality education. Our kids have a right to a free and appropriate public education under the law. As parents, we will fight, we are vehemently opposed, and we are demanding that an accomplished and experienced educator lead the New York City public school system, the largest public school system in the nation. I'd like to introduce to you our attorneys, Mr. Norman Siegel and Mr. Herbert Teitelbaum. Thank you.
Thank you, Mona. Yesterday, we filed an Article 78 proceeding challenging Commissioner David Steiner's November 29th decision to grant a waiver to Kathleen Black, holding she is qualified to be our next school chancellor. We allege that decision was contrary to law, an abuse of an authority, an abuse of discretion, and arbitrary and capricious. The critical facts in this case are not in dispute. What is disputed is the meaning of the governing statute and the regulations. One need not go any further than the language in the statute and the regulations and the decision to find that the commissioner violated the law, exceeded his authority in granting a waiver to Ms. Black. First, the commissioner's reliance on the qualifications of persons other than Ms. Black, especially Mr. Saransky, is not permitted. The linchpin for finding that Ms. Black's qualifications were substantially equivalent to the specified requirements was the commissioner's mistaken belief that he was authorized to rely upon the educational knowledge, skills, and experience of staff, especially Mr. Saransky, rather than Ms. Black's knowledge, skills, and experience. This is made abundantly clear by the language that the commissioner used in his decision. And in fact, the commissioner concedes that Ms. Black herself possesses none of the requisite educational qualifications except a college degree from Trinity College in Washington, D.C. Neither the statute nor the regulations permit reliance on anyone's knowledge, skills, and experience other than those of the candidate. Given that the statute was enacted and the regulations were promulgated with reference to only the candidate's qualifications, and without any provision authorizing consideration of the qualifications of others, an irrefutable inference must be drawn that the legislature of New York and the Department of Education intended not to authorize such consideration. Second, the commissioner's waiver of the master's degree requirement is not permitted. While the statute allows an exception for a candidate who does not meet, and I quote, keyword, all of the graduate course requirements, unquote, provided the candidate otherwise meets the substantial equivalent test, it does not allow an exception for the lack of a college or a master's degree. Ms. Black has the college degree, but not the master's degree. In sum, on this key legal point, Mr. Teitelbaum and I will argue on December 23rd for the 13 parent petitioners and the 1 teacher commissioner, the commissioner's belief that he was entitled to grant significant weight to the education, skills, and experience of persons other than Ms. Black, and his belief that the master's degree requirement could be waived was a misreading of the statute and regulations. Let me conclude on a personal note. I'm a proud graduate of the New York City Public Schools, and it's because of that, in part, why I am one of the attorneys in this important case. I do not appreciate the mantra of the Department of Education spokespeople when they continue to say over and over again, as they did once again yesterday, quote, in essence, it's time to stop the politics and rhetoric and move on. This is not about politics. This is not about rhetoric. It's about the rule of law and holding government officials accountable. When people say events like this are staged, as a lawyer for the people behind me, this is not staged. These are real people. I respect them. They fight for their children's education and their children's future. And anyone at DOE who misconstrues that, you don't get it. Once again, the public school system in New York City, especially the great teachers that I have had, helped me become who I am today. And today, and especially on December 23rd, up in Albany, I, with my co-counsel, Herb Teitelbaum, on behalf of the people here today, we will fight for public education. We will fight for the public school parents. We will fight for the public school children. And of course, as lawyers, we will fight for the rule of law. Thank you.
Is there anything more important than the educational future of our children in New York City? I don't think so. Is there anything more important than holding public officials to the laws which govern their conduct? I don't think so. Once again, what we're seeing is 1.1 million school children and their families being shortchanged. It's happened again and again, and it's happening now. This lawsuit is not about Ms. Black. I'm sure that Ms. Black is a very smart, competent CEO of publishing companies. But she doesn't have a whit of experience in the field of education. What does that say to our children? What does that say to our parents, to our clients behind me? What does that say to the educators within the school system who've worked hard to obtain their degrees to deliver educational services to the kids? What it says is that your training is really not that important. So this is not about Ms. Black. This is about an end run around a statute which is clear. And it's apparent from the commissioner's decision that this is an end run. So as my colleague Norman Siegel has said, we're going to fight this cause and do everything we can to set this right.
Have your name, sir?
I'm Herbert Teitelbaum.